What's up, everyone? So, how can you lock in a parenting schedule on the very first court date without a lawyer? That's what we're going to talk about right now. My name is Robert Buchanan. JointCustodyAdvocates.com is the website. I'm an attorney that practices divorce and custody, and I want to demystify it here for you. So, you're representing yourself. You've gotten far enough that you filed a motion to set a parenting schedule, and now you're going in on that very first court date. The challenge here is, how can you walk out of that courtroom on the very first day and have a schedule set? Because technically speaking, in Illinois, that first court date's called presentment, and the court doesn't necessarily have to order anything, or can't necessarily order anything unless there's an agreement of the parties. But so very often, I'm able to go in with my clients and walk out with a court order, a scheduled parenting time. So you can do that too. You don't need me to do it. And here's how you can. This isn't rocket science. So the first thing is that it's very important that the other side is there. If they're not there, you're not going to be able to enter this order. So do what you need to do to make sure that they get proper notice and they have an understanding that something very serious is going to happen in court, so it's in their best interest to show up. Once they do come to court, and once you get to court, first and foremost, you're going to check yourself in with the clerk. You're going to tell the clerk that you have a case. That clerk is going to probably ask you for what you filed, so have those documents on hand. The more prepared you are, the more credibility you will have with the court. So always have whatever documents that you filed on hand. Be polite. The judge is looking, the judge is watching. Even if you don't think that they're paying attention to you, they are. They are going to pick up on whether or not you're being polite to their staff. So be polite, no matter how impolite their staff is. Clerks are busy. They're not in a customer service industry, so they might be short, they might be curt. No matter what, you're going to kill them with kindness. Once you check in, you're polite, you tell them what you're there for. What you need to do is whatever they tell you to. Sorry, I was distracted by a Slack message that just came through on my computer. I should probably turn that down. Let me just turn this down. Okay, so we won't get distracted anymore. The clerk will then probably tell you to take a seat, and then your case will be called. When you step up to the judge, again, just be polite, be pleasant, introduce yourself to the judge, tell the judge that you're representing yourself and you don't have a lawyer, and that you filed your motion. And if you feel comfortable with it and the other side is to your right, introduce the other side. Say to the judge, if I was representing myself, I'd say, Judge, my name is Robert Buchanan. I filed a motion to have a parenting schedule set, and to my right is the other side, the mother of my children. Her name is Jane Doe, and I believe she's representing herself, but she can tell you that once you inquire. At that point, the judge will probably take the reins. You could, before the judge takes the reins, you could kind of just let the judge know that you have your expectations in the right place and offer to the judge. You can say to the judge, Judge, if you'd like, I can give you the basic information about this case, and then go from there. And if the judge says sure, then you just want to say, how many children there are, how old the children are, and who the children are currently living with. And then you can ask the judge, is there anything else you'd like to know? Do not fall into one of the most common things that people fall into when they are representing themselves, and that is getting into the merits of the case too quickly, getting into the weeds, wanting to talk about why things broke down and why you're in court and whose fault it is. At this point, at this stage of the game, the judge doesn't care, and if you go into that, you can almost guarantee that you're not going to walk out with a parenting schedule on that same day. This is about taking baby steps, appropriate steps, building goodwill with the judge so that the judge wants to do you a favor. You've been such a good litigant. You're so polite, so credible that the judge has no reason but to want to kind of assist you here. And so once the judge takes the reins and kind of asks the questions that the judge is going to ask, you can tell the judge, you can say, ideally I'd like to set a parenting time schedule. I know that Your Honor doesn't order that today necessarily, but I'm wondering if me and the other side can come to some sort of agreement, whether or not we can enter a temporary agreement. At that point, the judge will probably say, yes, of course. And then you can tell the judge, you can say to the judge, well, can you just give it a chance to talk out in the hall and see if we can come to an agreement? At that point, the judge is going to say yes, or may try to broker an agreement between you and the other side right at that point. If the judge says, yes, we're going to pass the case, then you're going to go out in the hall. You're going to attempt to just get some sort of parenting time agreement with the other side. And if the other side absolutely does not want to agree to anything, that's fine. We'll deal with that in a second. Otherwise, if you can get a little bit of an agreement, if you can get the other side, let's say you haven't even been seeing the child and the other side says, okay, I'll agree you can have the child on Saturdays from 10 to 4 o'clock. You're hoping for overnights here, but at the end of the day, you're limited by the fact that you do have to get an agreement, and something is better than nothing, generally speaking. So see if you can get the other side to just agree to something, and then you can go back into the judge. When the case is recalled, you can say, Judge, we spoke, and I was hoping to get this, and she or he, as the case may be, offered this, and this is where we're at. And if you have certain judges will really kind of dive in at that point if they see that you are trying. And if you say, Judge, I was hoping to get overnights, Saturday nights, or whatever. I used to have that, and Mom doesn't want to give me that anymore, or Dad. And the judge will, I look at the other side and say, why don't you want to give him overnights? At that point, the door is kind of open, and that person's going to start talking about why and start getting into the facts. Do not fall into the trap of defending yourself right away. Don't defend yourself until the judge asks you questions. The judge is not believing what this person says necessarily. The judge is just picking up on what is the dynamic of this case. So at that point, the judge will start controlling the situation. Will decide whether or not they're going to push the issue a little bit further, or they might just say, listen, if you guys have an agreement on something, I'll sign it, but that's it, and then we can come back. And right there, you will have an agreement. If you come back into the court after passing the case and you say, Mom wasn't willing to agree to anything, the judge at that point is going to be very interested to know why. And experienced judges won't just take any reason, and they'll see very quickly that the other parent is unreasonable. So even if you do not get an agreement, you're going to set yourself up great, because the judge is going to have a clear understanding that this whole court process is unnecessary because the other side is so unreasonable, and that again is going to build goodwill with the judge. So even in the worst case scenario, you do not get an agreement here, you will have left a good impression with the judge that you're trying to be solution oriented, that you're trying to broker an agreement, and it's the other side that's just not willing to agree to anything. In the case that you do walk out with no agreement, or you can see that there is going to be no agreement, I would ask the judge to set the matter for a hearing. And if the judge is willing to do that, it means you get to come back And if it's set for hearing, then both sides will testify. The judge will decide what's appropriate and will set that temporary schedule at that point. Let me check my notes to see if I missed anything. Oh, one other option is, and this is especially in Cook County, is that you could ask at that point to be referred to a hearing officer, and that's a resource that the court has where they can basically send you downstairs to a individual, and I'm not sure if they're a social worker or a lawyer or a retired judge, but either way, it's a non-binding proceeding where this person spends more time with you two trying to broker some sort of agreement, and so that can make an agreement happen when one wasn't going to happen otherwise. So that's my my spiel, my 2 cents on how you can get a parenting time schedule set on that first court date without a lawyer. Comment below. Tell me what you think, what questions you might have, what you want to hear me talk about next, and I'll talk to you guys soon.